Alameda County Bar, where you find yourself today. And in our new space, which we're so excited to use to welcome all of you here. If you are not yet a member of the ACBA, we have materials out here telling you how fabulous we are, and I'm also happy to talk to you about that. We're delighted tonight to co-sponsor this event with Queen's Bench and also with the League of Women Voters of Oakland, who are here in force, and we'll be doing our timekeeping tonight. And I just want to really appreciate all of them, including Louise Anderson here, who really gave us a lot of technical advice. They have a lot of materials here about the League, and I encourage you to check them out. They have all kinds of information, and now is the best time ever to be an informed voter. So let me just make sure to go over a few logistics. So tonight we're going to hear candidates for 2 races, seat 11 of the judicial seat 11, and then the district attorney position. We'll be starting with the judges, with the candidates, obviously, for the judicial seat. The moderators for that piece will be Judges Steve Austin and Judy Johnson from Contra Costa Superior. Thank you so much for schlepping here and joining us. Then we'll take a brief break, and then we'll switch to the district attorney race, and the moderators for that will be Alice Chung and Colin Bowen, and you'll meet them later. Each set of the moderators have some questions to start off with, and then they have some other questions. But if you like, you may ask questions, and Louise has a bunch of blank cards here. Please feel free to write a question. A few requests about writing questions, and then you can give them to either Louise or myself. The moderators have entire sole discretion about whether to read a question or not, or to modify the question in some way. Because we have a lot to get through tonight, we ask that you limit your questions to 20 words or so. We've heard a lot of questions in some of these forums that have gone on for pages. Please don't give us that. And do your best to give us questions that are directed or can be directed to both candidates. That's our format here today, is that each candidate will have a chance to answer the same questions. Please hold your applause until we get to the end of this round of candidates, and then we'll have one resounding round of applause. If we applaud whenever we feel enthusiastic, we will be here until midnight, which seems like generally not a great idea, even though I do love being here with you all. On a less exciting note, the restrooms, the one downside to our new space, the restrooms are all the way down the hall, so if you're running short on steps for today, this is your moment. All the way down this hall and to your left. And they have codes, so we have little slips of paper you can take with you. The code's posted on the wall too, but I find that I've forgotten it by the time I walk down the hall. So we have lots of food and drink back there. Please help yourself to it whenever. The candidates were told they couldn't bring in any campaign material at the beginning, but we will have, for those that brought campaign material, we will have it out on these tables after the event, when you will also have a chance to mingle with the candidates. All right, so have I forgotten anything that I was supposed to say, Louise, Valerie? No? Okay, so now I'm going to turn the floor over to the judges who will give us the rules.
Hello, everybody. I'm Steve Austin, and
I'm Judy Johnson.
And we're over from Contra Costa County, try to assist and be moderators here. I'm going to be asking all of the questions, but that's not because I brought them all up. We've worked together, and we're going to be having questions from the audience. Judge Johnson's going to be able to be going through the questions and selecting those and giving them to me to ask as we're going along. Each candidate will have about a minute and a half to give an opening statement, starting with Judge Flangan. Then we'll pose some questions. For each question, the candidate will have a minute and a half to answer the question. The League of Women Voters will keep us on time and show the candidates a sign for 30 seconds left and stop. When the stop sign goes up, please stop speaking. we will alternate which candidate answers the question first. The last question will be the speed question, with each candidate having 30 seconds to answer it. Then each candidate will have 1 minute to give a closing statement, starting with Ms. Katz. Judge Flanagan, your opening statement starts now.
Thank you, Judge. Good evening, everyone, and I'm so honored to be before the ACBA. Thank you for coming tonight. I'm Judge Tara Flangan, and I've been your judge since being elected in June of 2012, having served, having been sworn in January of 2013. And it's been my honor and privilege to serve as the Alameda County Superior Court Judge. I prepared myself, I hoped and thought, as an attorney to become a judge by working first in civil litigation as a young attorney and developing a skill set for civil litigation. Then I was a prosecutor in Los Angeles County where I earned distinction and being named an outstanding domestic violence prosecutor in a very large 1,100 attorney office. And therefore, I was seeking to gain some experience and expertise in criminal law. Lastly, when I returned to the Bay Area, I became a legal aid attorney helping domestic violence victims through the Family Violence Law Center here in Oakland. And that gave me experience helping basically low-income, no-income marginalized people, and also with family law and understanding family law in my experience. I've been deeply involved in the community. Many of you know me through the ACBA, through the Voluntary Legal Services Corporation, through committees and organizations that I've served in this county since 2004. I was on the Board of Women Lawyers of Alameda County and California Women Lawyers. And this type of community involvement has engaged me in the community, and I think helps me be a better judge with that experience. I'd like to tell you more, but my time is up.
Go ahead, yeah.
I will bring compassion and fairness to the bench. For 30 years, I represented the poor and outcasts of society. I paid attention to people who might not have gotten any attention from society at all until it was time to lock them up. I provide a quality service for people who might not have had a quality service in their lives. And I want to bring that quality service to the bench, not as an advocate, but as a fair and impartial interpreter of the law and as a follower of the law. My 30 years as an Alameda County public defender gave me a broad perspective on our justice system. I was in court almost every day. I know that victims are often every bit as poor as the defendants. I know that victims are often the same race and ethnicity of the defendants. I will not favor either side. Racism, sexism, and homophobia will have no quarter in my courtroom. I have empathy for everyone involved in the courts, and I also think that the advent of the body camera worn by law enforcement is one of the greatest forces for justice in the modern age. I will work to establish a restorative justice court in Alameda County. I think that court can be a place to repair community bonds instead of destroy them. And also, like the Chief Justice of California, I'm in favor of bail reform. I will not make inequality worse by keeping a poor person in jail who is not a danger to the community.
All right, we'll start with our questions. We're going to rotate who goes first on the questions. For this first question, we're going to start with Judge Flanagan. Every person comes in with some biases. What are yours, and how do you intend to deal with them on the bench?
Well, I think that that's a fair question because anybody who says they don't have any bias is fooling themselves greatly. Implied bias, implicit bias, things that we all learn through society and our life experience saturates us, sinks in with us. We may have direct experience being the victim of such bias. So these things we all carry with us. Part of the judicial education that I've participated in involves training in implicit bias and understanding how to be aware and what triggers one might have. And I think that the first thing is being aware and saying we all do have biases, and what are they, and understanding them through training and through education. What I try to do is take a deep breath at times and say, let me reverse the parties, reverse the genders, or reverse the roles, and say, would I be making this decision if the parties were switched? This is a common, I won't call it a trick, but a procedure that I would use when I was in family law, because you would often have a heterosexual man and a heterosexual woman on opposite sides of the case. And you would have to say, all right, let me reverse the genders and see if, as I'm about to make this ruling, if I would make the same ruling if if I did that. That's one trade secret type of thing that I employ. So I think the first issue is to be aware. I'm greatly aware of the bias and discrimination that people feel in our society. My legal aid clients who are often people of color, people of low and no income, and suffered bias, and I understand that and I'm aware. Thank you.
Ms. Katz.
I think bias is one of the biggest problems in the justice system today, and I would not exclude myself in an examination for bias at all. I think that given my 30 years of experience fighting for the underdog, I think I've seen bias go in one direction, unfortunately, many, many, many times. And I do think that there are people who are getting less resources and less consideration based on the fact that they look different from people who are in power and the fact that they behave differently. And I think there's also bias against people who don't have any money. I noticed in myself, it was easier to get along with clients who had a little more education. It was easier to get along with clients who were a little bit better socialized. But I had to dig deep into myself to try to relate to people who really were sometimes the dregs of society. And I think that I was able to do that by keeping my eyes on the principles of justice and knowing that a courtroom is supposed to be a level playing field regardless of status, and I keep that in mind.
For Ms. Katz, do you think a judge should act or behave differently when dealing with an unrepresented litigant as compared to dealing with one who has an attorney? And if so, how?
Well, an unrepresented litigant should be urged to get a lawyer. And believe me, I would do that. However, at times, people are unrepresented because they want to settle their case in a hurry. And unfortunately, I've seen people who wanted to proceed with a simple case where they just wanted to settle it, forced to come back again and again and again because they said they'd like to speak to an attorney but never said they actually wanted to hire an attorney. And I feel that that was extremely abusive, and I would not do that. However, I would warn, as the law requires, a litigant who is unrepresented that they are not going to get special treatment. But at the same time, I wouldn't want them to be rolled over. And I wouldn't want them taken advantage of. So that's a tricky question. Thank you.
Well, the law says that a judge cannot treat either party disparately, despite whether they have an attorney or not. And there's actually a case on point that I came across very often when I was a legal aid attorney from the Court of Appeals here in California that says it was error for a judge to sort of go bend over backwards and try and help the self-represented litigant when the other party had a lawyer. So that's the law, and that's what a judge must apply. What I do find, and having started in family law in my first 2 years, we have so many self-represented litigants. It's a very sad state of affairs because the reality is there's a lot of lawyers in this room, and having been one, folks, people can't afford us, and we know that. We know that. And so we have to find a way to try and make the most level and equal playing field for all the litigants in our courtroom. One of the first things that I do is refer people to the Alameda County Bar Association Lawyer Referral Service, because I work with ACBA, I'm on the BLSC board, and I try to explain about the programs and the opportunities, at least have a consultation for $30 for half an hour. At least go meet with somebody. Maybe you can work out a payment plan. But the reality is people can't afford lawyers. So as a judge, being mindful that I can't help them, one thing I do and have done is try to explain things as clearly as I can. Don't expect them to have the understanding of what is a motion in limine, what is an objection, what does hearsay mean. I try to at least explain and share that information.
For Judge Flanagan. Superior Court judges can be assigned to a wide array of civil, criminal, and juvenile cases. Describe how your past experience qualifies you to best serve the public across so many different areas of the law.
Yes, as I touched on in my opening statement, as an attorney, as a law student, I hoped one day, I dreamt one day of becoming a judge, and I thought, what does one need to know to become a judge? And I thought a breadth of experience. I thought the big three is civil, criminal, and family law. And so I tried to prepare myself to be able to handle an assignment in any of those types of law. And in fact, I had on the Superior Court. I was a civil litigator in a large law firm, did a lot of business litigation and employment law, some RICO actions, business and professions code. I understand civil discovery laws, and I understand that process. And that helped me out a lot when I was in small claims court, because so many people come to court with a breadth of legal issues. It's like law school 101. You have to be prepared and able to respond. I was a prosecutor in LA County, and that developed my trial skills, my jury skills, as well as my criminal law background. That was very helpful, and it helps me now. I have served in the criminal courts for about 2 years now. And for juvenile law, I don't have any direct experience in juvenile law, but I spoke about my work with domestic violence victims here in our county. And that's family law and child custody issues and child wellness and family wellness and health issues. And that served me very well and prepared me for family law. And then my connection in the community. In my former work as a legal aid attorney, I know all of the legal services provided in this county, and I can refer people and help attorneys even and litigants make connections.
Right, Ms. Katz?
I was a public defender for 30 years. I served in various capacities. I represented juveniles. I was the head of the juvenile division for a short time, and also mostly I served adults. I was in court almost every day. So I know how a courtroom is supposed to work. I have experience handling large calendars and interacting with a court staff and the public and clients and witnesses simultaneously at times. That will serve me well in family law and also in any other courtroom. The election is June 5th, but the term doesn't start until January. And if elected, I will be studying for that 6-month period. I have friends in other areas of the law who will help me. I have friends on the bench who will help me. I will be well prepared by the time I take the bench.
All right, Ms. Katz, here's the next question. In our judicial system, daily calendars are packed. The judge is tasked with ensuring that the court's business is efficiently handled within limited time. Given those pressures, what is your philosophy about how a judge should treat attorneys, parties, and jurors to ensure that everyone is treated in a fair and respectful way while still getting the calendars done?
Well, I have a tremendous amount of experience with big calendars, as I said, and I have found what helps the most is to allow people to be heard. People need to come to court and feel that they're being heard and that what they say is having an effect on what's actually happening. A judge should be preparing the night before, if that's when they get the calendar, or further in advance if it's a difficult case that's been postponed for decision or further briefing or whatever the case may be. I think treating people with courtesy and respect goes a long way. I think the court staff needs to know that I have their back, and I would have their back. I think that witnesses need to understand that I know that they have a life outside of the courtroom, and litigants as well need to know that I understand that what's happening in court is important and not just another case.
The calendars are packed, particularly in the criminal law department where I serve. There can be days when we have over 100 cases, misdemeanor cases on calendar. And the idea being that you're to address those cases between 9 a.m. and 12 noon. So many of us got into law because we don't do math, but that's not a lot of time per case. So I think one key ingredient to moving the calendar is to be prepared. Read it in advance, read the allegations, read the charges as best you can, Certainly in criminal law with 110 cases, that's a little different than family law when there are pleadings and motions and things filed and you have more advance notice of what is coming before you in advance. So as a judge, being prepared, but also having expectations of everyone before you, that attorneys are prepared themselves and they know and understand that that's their job, to be ready to go and to work things out and allow people time to talk as necessary. Nobody should come and call a case and have it be called when they might be working out a resolution. I'd gladly give people time, a few extra minutes or whatnot, or an extra half an hour if they need time, and work late as needed into the lunch hour for them. I think it's very important though, and this is something that I try to do every day, is look people in the eye, the litigants, and say good morning, and wish them luck if their case is over, if they've entered into agreement, they've entered into a plea deal, or it's the last time we've seen them where the case is dismissed, to say good luck to you, take care of yourself. And that takes time, but it's time well spent.
All right, Judge Flanagan, you are, or previously were, this is asking for both of you, advocates. How have you prepared yourselves to step into a role as neutral?
You know, as I prepared to run for judge in 2012, I found myself, as my legal career advanced, I was a fierce advocate, and when you're representing victims of domestic violence, there's no greater fight to fight in our courts, in my opinion, than helping battered persons and children get safety, get restraining orders, to be able to move on with their lives. So I think I had a reputation as a very strong advocate for my clients. But as my career developed, I became less interested in many cases in what someone wanted, per se, as to what was the right decision, what was right, what's the middle ground, what's the sweet spot. So I think there's an evolution in a lot of lawyers who do become judges in reaching that point of looking for what is best, not what just does our client want. And so I think there was, myself, I experienced that evolution. And then also, one of the beautiful things about being a judge is you don't have a dog in the fight anymore. It's actually very freeing to be open and to listen and to weigh things evenly. And you have to be mindful of your own experience. You have to say, well, I was a domestic violence attorney, but I also had a private practice where I represented alleged abusers of domestic violence. So being open and being able to see both sides of things, I think, is a very, very good experience that served me quite well.
Ms. Katz?
Well, there's nothing like being a public defender for 30 years to enable you to see both sides of a situation. You know, one of the reasons I was successful in jury trials is because I could understand where the victims were coming from. I understood the witnesses. I understood the juries. And quite frankly, I represented some people who belonged in prison. And I understand that some people do belong in prison. And I would not be putting a finger on either side of the scale. As a neutral arbiter, I understand that the only way the system works is if a judge is fair and doesn't give any weight, any additional help or weight to either side. It's extremely important to realize that people in this system often bring a tremendous amount of integrity. Lawyers work hard, they believe in their cases. Parties believe in their cause. Police officers, by and large, are trying to do their job. And now there are body cameras that hold police officers accountable. And also, people are just looking for fairness and know that a judge, I know that a judge should be there to give that and not give weight to either side.
All right, then Ms. Katz, here's another question. Please give us an example where you had to balance the law against what you felt was the right thing to do. That's a hard one to think about.
That's a tricky question. So a situation where the law was telling me not to do the right thing, I'm not sure I really understand that. You know, People would ask me, how could you defend those people? And I would say, because that's the law. Everyone deserves an advocate. There's a prosecutor whose job it is to convince a jury beyond a reasonable doubt of the truth of the charges. There's a defense attorney whose job it is to advocate for someone who has that attention paid to them and has the job to put the prosecutor to the test, and then it's up to the jury to decide. I never thought, when I had occasion to defend someone who might have committed a horrible crime, that I was doing the wrong thing. I thought I was following the law. And I never was tempted to cut corners or do something unethical in zealously representing someone. Because that's the way the system works. If everyone plays fair, the system works. And so I am, perhaps if I had longer to think about it, I would think about a situation that was a conflict like that, but I'm not coming up with one right now.
Okay, Judge Flangan?
Well, I think the beauty of the law, and why I love the law, is it's not always so black and white. There's a lot of gray. And as a judge, there are some things upon which you have discretion, and you may exercise that discretion. And that doesn't mean that the law or you exercising your discretion might not be the right thing, or may be the right thing. First, you have to apply the law. Let me give you an example. In a criminal court assignment, I can talk about this case because it's resolved. Several years ago, there was what's called a felony preliminary examination. The charges against a young person alleged to have committed a felony. And there were witnesses called. I oversaw and heard the hearing. And every single element of the felony had been met. It involved evading arrest in a car chase after a sideshow. And the witnesses were done, all the evidence was received, and now came the argument. And the argument and the request of the defense attorney was that I reduce this matter, exercising my discretion under Penal Code Section 17B, from a felony down to a misdemeanor. Every single element of the felony had been met. But I considered and heard the circumstances in aggravation and mitigation. And this offense had been conducted by a young person who was just turned 18 years and 3 days. Had they been on the other side of 18, they'd be in the juvenile court. Should this person, whose brain really isn't fully developed at that age, be charged and held to a felony? He won't get any financial aid. He won't get public housing. And I made the ruling. I did what I thought was right in my discretion and just reduced it to a misdemeanor. That, I think, answers that question.
All right, Judge Flangan, what should a judge do to make sure prospective jurors have valid reasons for not serving on the jury?
You know, there are actually websites, how to get out of jury service. Has anybody looked at those? Don't, it's horrifying. Actually, it's entertaining. But this is an issue that's a struggle, certainly here in our court system in Alameda County. We have such a low turnout at my courthouse, Wiley Manual, for people who are summoned to jury service. In fact, I had a jury trial in the last 6 months, and the jury commissioner had to send out over 550 summons to have 70 people show up. So where were those other 485 people? They were in the garbage can, I guess. I don't know. So the first thing I think we need to do is to engage our community and say, jury service is not only a right, it's an obligation. Just as I feel voting is an obligation. We all are members of our community, and we need to be engaged. That's the first thing, and the court is looking at that. We're working on that, how to get our community more engaged. But we have standard voir dire questions that a judge asks as we have panels brought in and we interview the jurors. And you know, I think that you ask the questions and urge people to be candid, but also to be honest. If they answer a question that it seems like they're just trying to get out of something, like they say, well, I don't think I can be fair. Well, why is that? You ask a follow-up question, like an attorney would. What do you mean by that? Well, you haven't met this person. You don't know anything about this case. So if you just met the person sitting next to you, would you make a judgment about them? To try and explore and flesh it out, and really invite the jurors, the attorneys, to do the same thing.
I think the problem is in a lack of response to the summons, and I think something needs to be done about that. I think outreach and education would be helpful, and I think perhaps a little teeth in a response when people do not respond to the summons might be in order, something small. But in the meantime, once people come to court, if there are many, many reasons why people cannot serve. They're not going to get paid. They can't sit for a certain amount of time. Something about the case makes them upset. They don't think they could be fair. You know, for people who don't think they can be fair, I do think that it's important to inquire because, unfortunately, it tends to be certain kinds of jurors who don't think they can be fair, and letting people go sometimes, I think, impacts the fairness of the panel. But as far as hardships, I think that those people should be let go. I don't think it serves any purpose to keep people who are saying that they, who are saying under oath, after all, that they have various problems that will make it impossible for them to serve or tremendously difficult. I think that those people should be respected and let off the jury.
Ms. Katz, is there a need for more mandatory mediation or settlement efforts? And if so, what specifically would you propose to do about that if you're elected?
Well, I assume that that is a question that is referring perhaps to civil and family court matters. And I tend to think that given that there's the backlogs that we have, that most likely it would be a good idea if there was a good, more effort given to mediation. I know there are professional mediators, but from my experience in criminal court, I think that judges can do more to help settle cases. I think that a judge, certainly in criminal court, can do a lot to engender a fair resolution. A judge typically has a lot more experience than the lawyers, and that can help. Judges also sometimes are more engaged with the community and know of various resources, and so I do think that judges in criminal law should participate more in trying to negotiate cases.
Thank you. I think that it certainly is imperative of a judicial officer to help settle cases as best they can, and there's different styles and different ways of doing that. But one thing sort of procedurally or systematically that can be done, I think, in the civil context and the family law context, we let cases go a long way down the road before we invite or set a settlement conference, for example. And I think that if we try to run perhaps tighter timelines, we don't necessarily need more hearings because our calendars are quite full in the civil division, and it can take months and months and months to get before a judicial officer. But to have mandatory dates and guidelines that are set in, that is the expectation of the attorneys. When I was an attorney, I had a family law case out in Marin County, and they had a mandatory mediation type of program that we had to go to, and it was essentially working the case up to trial. We couldn't opt out or choose our way out of it. And it was only about 6 months into the family law case, which is quite young for the family law attorneys in our courtroom that know that. And I found it very painful, actually, to be prepared to go to trial in 6 months and do what I needed to do. But it also helped settle the case sooner, and I think it was a knowing and intelligent settlement. So I think setting guidelines and looking at that. And I think that it's up to a judicial officer with experience in courts and cases to say, look, this is, call the counsel in and say, what are the issues? Help narrow the issues and say, this is what I think, how the rulings would go on these evidentiary issues and whatnot, and try to narrow it. I think the judicial office can play a big part.
All right, Judge Flanagan, please describe a courtroom situation that tested the limits of your patience. How would you respond?
Well, there can be a lot, because the reality is, folks, that nobody wants to be in court except maybe us because we work there, right? Families are in great stress and under great duress. People are suffering in physical ways, financial ways, emotional ways. People are charged with offenses that their liberty could be at stake, their future could be at stake, like the example I gave you with the young man. If he had a felony conviction at some point, he would lose many opportunities in life. So people are not always at their best, and I think that one day in criminal court, we had a case where a woman needed to be prioritized, to ask the staff to prioritize her case, and usually you need a health reason or something like that to do that. Everybody wants to go first and be out of there. But she gave word that her family had suffered a big loss the day before. Her son had killed himself, and she was here to be arraigned, and she had managed to pull herself together through her grief and come to court. And she actually had a breakdown while addressing the court. She didn't have an attorney yet, and it was very difficult and stressful for everybody. This person was in great pain, and she asked me, could she have a hug? I came down off the bench, which you're not supposed to do, by the way, and go into the well, frowned upon, and I gave her a hug because she was suffering so much. That was a very stressful and difficult day for everybody.
Ms. Katz.
There are many times where my patience was tried when people who were not a danger to the community were held in jail on unreasonable bail. And what I would do in those situations is I would work very hard to get the bail lowered, but I was often left with my frustration because I was unable to do so. I had situations where women were held in jail and their children were picked up by Child Protective Services. I had situations where people lost jobs. I had situations where people lost their homes, and I had situations where homeless people lost whatever belongings they had. That was a constant source of frustration for me, and I don't know that I ever got over it. I don't think that that situation should continue, and one of the reasons why I'm running for judge is because I, like the Chief Justice of this state, believe that there should be bail reform. And in the meantime, I think a judge should set bail that is affordable and also takes into account public safety.
All right, Ms. Katz. Alameda County has a broad range of racial, ethnic, sexual orientation, religious, and socioeconomic communities. What experiences do you have, including volunteer work, that would give you sensitivity or expose you to different viewpoints of these groups?
When I came to California, I joined the United Brotherhood of Carpenters and Joiners because I had some woodworking experience. I was the only woman in the local, and I think I was also the first woman in the local. Unfortunately, I was scared of heights as far as standing on the narrow end of a 2x10, so I decided I had to go back to college and become a lawyer. I am the bisexual mother of a gay son, and so I have those sensitivities as well. My children went to the open public schools, K through 12, so I am well acquainted with people of various nationalities, ethnicities, levels of wealth, and because I'm friends with the people I met through my kids, as I'm sure all of you are, and have socialized, and also wound up advocating for them. The experience, the richness of sending your kids to open public schools is something I would not trade, and it has it exposed me to something I call the culture of defeat. Things would happen at the school, and someone would say, well, they told me I just couldn't do this and that, and I would say, well, that was the first thing they said. That was the first time they said no. And, you know, my time's up.
Yes. First of all, I have a lot of experience in organizational capacity working with different groups of our diverse community. I am the co-chair of the Alameda County Bar Association's Diversity Bar Coalition. So part of the work that I do with Tony Mems-Cochran is to coordinate and work with all of the different bar associations and different diversity organizations in our county to help our justice system be better, our court system be better, and to streamline our response to different community issues and concerns. And that, of course, connects me with a breadth of the beautiful, diverse community that we have here in Alameda County. I was previously on the board of California Women Lawyers and Women Lawyers of Alameda County. These are two organizations that fight for justice for women in the law and in the practice of law. And if you've been following the Me Too movement, guess what? It's not new. We all have been working on these issues for many, many years as women attorneys. And that's an experience that I have. I am a lesbian. I ran in 2012 as an out lesbian and talked about my diversity and my experience of being someone who's different in our community. And I think that's a very important perspective to have for a judicial officer. I talk about this in my campaign, but it's important. I want to share it with you. My first 6.5 months as a judge, I was in family law, deciding cases related to marriage. The detritus of marriage, perhaps, but marriage nonetheless. Yet I myself could not get a marriage in the state of California. It was illegal for me to be married. I understand being the other.
All right, for Judge Flanagan, what are your feelings about the Citizens United decision?
This type of question comes up often, not particularly about Citizens United, but what are my feelings about this law or that law? And I don't wish to be evasive, but there could be a time at some point in the future when a case that's similar or related or drawing upon Citizens United comes before me as a judicial officer. I cannot speak to a case or answer ethically about what if, because I'd be giving an advisory opinion of some sort. I have to be mindful of my judicial ethics. But another thing that I want to say is that my job is to administer the law, to apply the law fairly and to the issues before me, the parties before me, and the people before me. What my personal opinion is not relevant. I have to leave that at the door. There's certainly, I would, if I were candid, there's many things on the books that I don't personally agree with or I find offensive or discriminatory in some way, but that's not the job of a judge to have an opinion on that. It is the job of the legislature to change those laws if we, as a community, as a society, feel that they should be changed. And so it may seem evasive, but those of you who are lawyers in the room, you understand why I feel my opinion of Citizens United is not relevant to my work as a judge.
Okay, Ms. Katz.
Well, a judge is entitled to her opinion, but it is true that a judge should never appear to be biased. A judge should never appear to commit herself on a case or controversy that might come before the court. I will tell you that I personally am not in favor of the Citizens United decision. I think it was an unfortunate development for the politics of this country. However, I would also put that aside if a case were to come before me where I would have, in the very unlikely event that a case having to do with that would come before me, I would put that opinion aside as I would in any other matter where I had an opinion as far as what the law should or shouldn't be, because a judge has to follow the law, has to interpret the law and follow the law. And someone who has a different opinion from me needs to be assured that I would be fair to them and wouldn't allow my opinion on what should or should not be the law enter into it.
All right, Ms. Katz. If you observe a party in your courtroom who's being poorly represented by an unprepared or ineffective attorney, how would you handle that situation?
I would talk to the attorney. You know, I had a situation once where I actually had to call the district attorney up and tell him that his father, who was doing defense work, seemed to have deteriorated mentally, and that was a really hard call because that DA and I were not really on great terms, but no one else would do it because everyone was sitting there, everyone saw it happening. And I just had, I couldn't sit by. Unfortunately, it doesn't take mental deterioration to engender a poor performance. You know, I would bring counsel, both counsel into chambers and have a discussion as to my concerns about how the case was going, and you know, start with open-ended questions, because often the judge doesn't really know that much about the case. So it could be that a judge has a completely different idea and not a realistic idea of what exactly is going on in the case, and there could be there could be reasons that are not immediately apparent, and there could be reasons a defense lawyer would not want to reveal to a prosecutor, and that has to be respected. But if we got that far, I would feel better about how things were going.
It's a difficult issue, because what is well represented, right? Who sets the standard for that? Who defines what that is? Something could be egregiously obvious. You could maybe, as a judicial officer, sometimes tell it's someone's first appearance or their first time in a certain type of courtroom. And as a judge, you have to be very careful about not giving someone an advantage, and that means even trying to level the playing field for them. You can ask them questions. Do you mean such and such? For example, prompting a certain question that might elicit an answer just on procedural type of things, and that might prompt the attorney. But I think a judge has to be very careful, because what, again, who defines what is adequate representation? Some things might be so egregious that it jumps out at you. For example, counsel not objecting to evidence, hearsay, or things like that, things that are pretty basic law school issues that we all learn for the bar exam. And I've seen that happen in family law court. All you can do is, you're the referee, you call the balls and the strikes. You cannot try to fix it for somebody unless there's an egregious situation. Then you would maybe have a chambers conference, talk to the attorneys, and be mindful you're not addressing an attorney out of turn before their peer and saying, I'm concerned about your skill level. That's inappropriate, I think, for a judge. And there are remedies, of course, and it's a sad thing to say, but ineffective assistance of counsel in criminal cases, for example, that's a motion that might be available. Thank you.
All right, we're nearing the end of our time here tonight. So we're going to enter into the lightning round. So we have 30-second answers, okay? It's the last question, it's a 30-second answer. And I'll start with Judge Flangan. In one sentence, what specifically differentiates you from your opponent? I don't know about one sentence. That's even
that's two tests. That's lightning and one sentence.
You got the 30 seconds, okay? Let's start now.
I am your Superior Court judge, and I have served proudly and with great privilege since 2013. And so I have been your judge for 5.5 years, and it is my honor to return as your judge. My experience in civil, criminal, and family law and domestic violence law gives me the breadth of experience, and also my experience as someone on the margins of society helps me, gives me a unique perspective as a judge.
All right, Ms. Katz.
I bring to the table years of experience that is not replicated by my opponent. My experience of representing people who have actually had their liberty on the line has given me an insight into the importance of justice and fairness, and I'm running to bring justice and fairness and compassion to the bench.
Okay, each now will have a 1-minute time to give a closing statement. We'll start with Ms. Katz.
Only about 8 of the 75 Superior Court judges have any experience as public defenders at all. And by my count, there are only 2 right now who were career public defenders on the bench. So that leaves a bench mostly composed of former prosecutors and former corporate lawyers. I think that my experience dealing with people who are not used to getting a fair shake and getting a fair shake for them gives me the compassion that is appropriate for a bench officer. And I think that my years of experience has made me want to be compassionate to everyone in the courtroom and give people the experience of being heard and being respected and being taken seriously.
Judge Flangan.
Thank you. It's my privilege and honor to be your judge, and I work very hard and work tirelessly every day to be fair, to reach the best decisions I can with the information in front of me, and to treat people with respect and dignity. And I make my decisions. It takes courage to be a judge, actually, because a lot of times half the room isn't going to be too happy, but you make the best decisions you can and treat people with respect and move on. I'd be honored to be returned to the court as your judge at June 5th. I have widespread support. Over 90 judges have endorsed me. The East Bay Times has endorsed me. The Democratic Party has endorsed me. Oakland City Attorney Barbara Parker, Mayor Libby Schaaf, elected officials up and down the county and throughout the state. And mostly my colleagues, because they know I'm the judge I said I would be, and they want me to return as their peer. And I'd be honored to have your support, and I thank you for being here tonight.
Thank you.
Thank you to both our candidates and to our moderators. Thank you so much. We're going to take a 5-minute break here. It is a little toasty in here. It is warm in the hall. Don't forget the restrooms are all the way down the hall, and take the code with you. In 5 minutes, we'll come back with the next round of discussions.
All right, we're going to be back at about 7:20, and we'll see you then. Sorry, I should have given you a head up on that. I'm sorry. As soon as I did it, I was like, that was a bad idea. Okay. Oh my gosh. It's a little bit late in the day for this morning. I'm like, trying to fall asleep.